When a police officer threatens to kill his ex-girlfriend and her family, is that legally sufficient for a conviction of harassment too? To find out, you have to read People v. Lagano. It's only 7 pages. Don't have time for that? I got you covered. This is the TLDR episode on People v. Lagano, found at 2022 New York Slip Opinion 07021, published on December 13th, 2022. This is a criminal case where the issue is about legal sufficiency of the statute for harassment in the second degree, which criminalizes making a threat against a person, a true threat. It's a fascinating case where the defendant is a police officer who had a bad breakup with his girlfriend, accused her of cheating, and then started stalking her. He then called her on the phone and she recorded the phone call. And in that phone call, he said he was going to firebomb the house. He would shoot her children. He accused her of extorting him. She then did not call the police immediately at that moment, but the following day reported it. The next day, with cooler head, the defendant reported what he did to his captain and admitted that he had threatened to shoot his ex-girlfriend's children. He was arrested. He did a bench trial, and the judge found him guilty. The Appellate Division reversed it, finding it was not a true threat, and it went to the Court of Appeals. And the Court of Appeals explored the concept of legal sufficiency with respect to harassment in the second degree. And they drew a distinction between an outburst or mere angry words versus a clear and unequivocal true threat. They made a point that there's no temporal requirement. It doesn't have to be that I'm going to cause the damage at this very second, that's not one of the statutory elements, but rather the fact that the defendant was a trained police officer, trained in the use of deadly physical force, the fact that he had these motives that he articulated, both extortion and cheating, all lent themselves toward the finding that, in fact, he did make a true threat, and the Court of Appeals reversed the Appellate Division, sending it back down to the trial judge, finding that under these circumstances, under these facts, these do constitute a legally sufficient case of harassment in the second degree when viewing the evidence in the light most favorable to the prosecution, which is how you view this kind of an appeal. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.